And then in answer to Lawtube, they don't understand retaliatory prosecution under the First Amendment. In fact, they seem to there's this guy, potentially criminal Sean. So just sort of, he looks like Jabba the Hutt, but retarded. So imagine a retarded Jabba the Hutt, and that's who this guy is. I mean, if he gets into court, a wheelchair wouldn't work. They got to roll him in a wheelbarrow. That guy.
I have no idea. I know who you're talking about. I have no idea what you're talking about. I just know that you took some shit on the internet verse for referring to.
Well, that's who he is. I mean, he's a total loser. And he's hanging out with these real sleaze bags, people that would make the Jerry Springer audience look moral and ethical by comparison. These people he's just grifting off of all the haters and the people who love to hate and just nasty, nasty people. But he's making up the laws as he goes along. They're not understanding the First Amendment. The First Amendment issue is selective retaliatory prosecution. He claims if you think judges could be corrupt or prosecutors could be corrupt or police, and this guy feigns criminal as a criminal defense lawyer, or cops could ever tell a lie, then that means you're a crazy conspiracy theorist. That's how lunatic this guy is. This guy has no business being a criminal defense lawyer. But retaliatory motive is all over the place as it concerns Rekieta involving the individual officers and jurists involved. The Second Amendment issue is pretty darn simple. Aside from the second Eighth Amendment issues of bail, not allowing you to take somebody's gun away as a condition of release when they haven't been convicted of a crime, the other Second Amendment issue, which apparently uncivil law. I mean, he puts on his little Texas hat on and he fancies himself a Second Amendment guy. I mean, he clearly just doesn't know basic Second Amendment law.
Robert Barnes is blowing people up tonight.
For those folks out there, I mean, our audience knows you cannot charge as a crime merely having a gun in the possession of drugs. Merely having it, but by the way, it turned out when we got the information, all of the guns were locked up. They were either secure in his private bedroom or almost all of them were in safes, gun safes.
And just to highlight the drug issue, they measured 26.67 grams, including packaging. Now, I've never done these drugs.
All of it, by the way, they also found in safes. So this suggestion that the little kids were sitting around and there's armed guns and there's drugs everywhere. Total lie. Total lie. He was not ever accused by anybody of child abuse. The pastor reported it, said, by the way, I want to emphasize there's never been any child abuse. None.
They said 0 reports of physical or sexual abuse.
Zero. People are libeling online. Saying that. So, but this guy's repeating those lies, this potentially criminal guy, doesn't understand the First Amendment. Second, uncivil law doesn't understand the Second Amendment. You can't charge somebody with it. It is not a crime to own a gun. It is not a crime to own a gun and also have drugs. It is only a crime to, in public, within the Second Amendment, to, while you're in public, illegally intoxicated, have a gun. That is the only thing the Second Amendment permits. It does not permit criminal prosecution like this law does as applied in this context. That's the Second Amendment issue, and they can't seem to figure it out.
Well, I'll stop you there. And if anybody disagrees with that, as a matter of fact, they'll snip this and clip this and say Barnes is wrong. You cannot have drugs and a gun in the same house. I do have my questions with that because you have guns and marijuana
being adjudicated in over a half dozen cases since Bruin. Remember, we've discussed 3 of those cases. Remember the Oklahoma case where it was pot in a gun, and it brought the challenge.
But some people are saying pot was a lower level gun than.
It doesn't matter what the crime, what drug it is. The court made clear all of these decisions, same pattern. Merely being illegally intoxicated, no matter what you're illegally intoxicated on, it is not grounds to take away your gun rights unless it's public. Merely having illegal products it is not grounds to take your gun away or punish you for having a gun within the Second Amendment. You've got to have to use that gun in public while illegally intoxicated. That's what court after court after court is ruling, and yet these so-called Lawtubers can't even research basic law.
And use could involve the mere brandishing or the mere possession. So it's not like you have to use it
as long as it's in public while intoxicated.
Okay.
Those are the other components. That's the only historically valid application of the Second Amendment in this circumstance.
Go for it.
Well, then we get to the Fourth Amendment, which they completely butcher. I mean, there's all these people in the Camelots of the world, the the umbrella guys of the world, these other people who now think the Fourth Amendment is a really low standard because the idiots on Lawtube have told them that, because Nate the lawyer has told them that, because Legal Mindset has told them that. And these are people who don't understand the Fourth Amendment to the Constitution of the United States. And they're frankly spreading fake news about the law. So to be clear, probable cause is a real standard. You can't search.
Robert, so I'll read it because I can actually see it with the screen open. The right of the people to secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause, not possible accusations of, supported by oath or affirmation, and particularly describing the place to be searched and the person or the thing. Robert, some people are saying, this is the argument. I'm going to swallow before I choke on my own tongue. The warrant was issued. Therefore, it's a lawful warrant, and anybody defying it is violating the law. That's the argument. I'm an idiot. I'm Canadian. How is that not a proper retort?
I mean, the problem with that is that it confuses what a prosecutor alleges with fact and what a judge determines with law. So to give you some examples of what the Minnesota Supreme Court and the United States Supreme Court have said, and the standard is identical in both jurisdictions because the Supreme Court has said the Fourth Amendment applies to the states through the 14th Amendment, is here are the things that cannot be probable cause. It cannot be casual gossip. It cannot be general reputation. It is necessary, and here's how hearsay rules apply. For example, Supreme Court of the United States, Supreme Court of Minnesota, both have quoted and said this at various points. It is necessary to evolve analogous guidelines to hearsay rules employed in trial settings in setting the standard for hearsay in a probable cause setting. So these people saying, "Oh, Barnes, hearsay is always allowed, doesn't matter." You're lying. You're lying out there. This is a Lawtube lying about the Constitution because they want to grift off the issues concerning Nick Rekieta. In fact, if you're using hearsay, here's what the Minnesota Supreme Court requires. Here's what the Supreme Court of the United States requires. There must be independent investigation that corroborates those facts. You must establish the veracity and reliability of the person giving you the hearsay. You must also establish what the basis of their knowledge is. There's a sequence of decisions that have repeated these principles again and again and again, none of which, by the way, is present in any adequate manner in the Nick Rekieta affidavit. Now, here's one of my favorite Minnesota Supreme Court cases. Guess what they have said about whether or not you can search a home based on substantial evidence that someone is a user of drugs, not a dealer, a user. Guess what the Supreme Court of Minnesota has repeatedly stated?
I have no idea. I'm going to say immediate risk of harm to children.
Well, no, just the opposite. What they have said is you cannot search a home based on the fact that someone is a drug user. That there is no assumption or presumption that meets probable cause to say simply because someone is a drug user in the past that they then currently have drugs at the home. They said that's not an assumption you can reach. That because why? Because they knew cops would abuse this like crazy to raid people's homes based on simply the allegation of illegal drug use. They're saying the allegation of illegal drug use is never sufficient constitutionally to raid someone's home. And yet all of Lawtube was too lazy or deliberately lied about the law to know that this is the Minnesota Supreme Court in the key leading decisions that has said that. I can quote case after case after case after case, quote after quote after quote after quote, that from the Minnesota Supreme Court and the Supreme Court of the United States that supports my initial proposition that this search warrant fails to meet probable cause under the Fourth Amendment. And they've utterly failed basic principles of Fourth Amendment law, failed to articulate what the standard is, failed to articulate how hearsay is applicable or inapplicable, failure to articulate whether social media gossip and church gossip can ever be the basis of a search warrant, failed to articulate that merely being a drug user in the past is not evidence of present possession in the home sufficient to give probable cause to search that home. So they violated one after the other, after the other, after the other, after the other, because what they gave was constitutionally illiterate, fake news legal advice from Lawtube. And it's sad and pitiful and of what they have become. That I had hoped they would be a check on the fake news from institutional legal sources over the last half decade. They've become instead advertisers and propagandists for that fake news, and in ways that are going to require calling them out on a continuous basis when they lie to people about the law and they defame our Constitution in the process.
Robert.locals.com.
One last addendum.
Go for it.
People can ask Legal Mindset, why did you move to a town that is world famous for child prostitution?
I thought you'd forget about
it. But the other thing is this. So I get what these people try to do is brigade your comment sections, brigade your chats, brigade your sex, and they use every method of harassment because their goal is to get you to self-censor. Oh, geez, I don't want to get all this criticism. I don't want to get all this hate. I don't want to get people creating fake anonymous accounts. I don't want to get people to create fake accounts that imitate me that are not me, create deep fakes of me saying things I never said, try to clip things out of context and attack me. Now, one of the ironies is all these schmucks, they're like, oh, we're here for the children, Robert. We're here for the children. All these Lawtubers combined, all these other, frankly, people combined, have done less work for victims of child abuse than I have. So they have no moral high ground to stand on. I have contributed over 10,000 legal hours pro bono to victims of abuse over the last quarter century, worth more than $5 million. So don't bother trying to come at me pretending you care about the kids. Because if you cared about the kids, you wouldn't want the government in control of those kids. If you cared about the kids, you wouldn't want traumatic raids of officers banging down doors and terrorizing them. So don't pretend you care about the kids. You don't give a rat's rear end about the kids. You're fakes, phonies, and frauds. You're a disgrace to the rule of law. You're a disgrace to decent society. And those people who think coming at me is going to work is not. So I'm going to be blocking people that bring in these trolls. I don't care if you're Ron Coleman, Nate the lawyer, Legal Mindset, who you are. That I'm not going to deal with that people making my Twitter feed toxic for other people who are trying to have informed conversations. You can make fun in a creative way and I'll leave you up. You can be critical and I'll leave you up, but not these toxic trolls of the Kiwi Farms world that loves to harass people into joining their social media lynch mob. This is the Springer-esque behavior that Lawtube has embraced is a disgrace to Lawtube and a disgrace to these people.